What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Wednesday. It is Wednesday. Happy Wednesday. Happy hump day. Hope everyone had a great day. Hope everyone's having a great week. All right. Who wants to watch some court? I want to watch some court. Okay. First clip, Judge Stevens. We got a Judge Stevens clip, and it was going to be a premiere. I had it all set up. I was going to release it at about 5. And then my good friend Lone Wolf, good friend of the channel, he tipped me off about the part 2 to the clip that I was going to put out that I didn't even know existed. So we got part 1 and part 2 on the same day. All right. Before we get started, we have a new member, Tom Charles. Thank you so much. Welcome to the family. I appreciate you being here. And I'm glad that you're not lonely in gray. All right. Who's ready? Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
We're gonna do on this.
We're still working on this one if we can get a little more time. About 4 weeks.
You got it. Lawrence Caleb. I have 2 cases on Lawrence Caleb. Do I need to be here for?
Actually, Ms. Bassard, she has an ankle monitor phone. She was asking relief from that. The reason she was given her ankle monitor is she was late for one time, and she's always been important. She has good contact with me. She's always.
I've never been.
Trust me, she calls a lot, so it's not a bad thing. It's a good thing. So
You only put it on because I was late for court one time, and I don't have no problem with it to court.
That's all it takes is one time.
And it's a lot of money, not that you can't afford it.
Did you Calvin Trahan? Here.
I think he's.
I think he's already gone. Give me that file back.
Bassard, he just handed you the file.
Bassard.
He handed the file over to reset.
Yeah.
Welcome everyone that came over from KCC. Is she already finished for the night? Did she go early? I have not really been paying attention too much over the last couple hours what was going on, but welcome to everyone that came over from KCC. She is also a good friend of the channel.
I've never been in trouble before prior to those charges.
There's a little bit of
Copy this,
downtime.
please. Real quickly, thank you. Not gonna happen. You haven't been paying Johnny's. Too little, too late, man. You're not gonna get your wish. Kind of let that part out there, didn't you, about not paying Johnny's? You sent that in January, looks like, or February.
I'll make sure I let her know she needs to take care of it between now and next quarter day. Catch up on that.
No way to handle my bond orders.
You should go and step on the sign for a reason.
No. You're not going anywhere right now. Let me get a copy of that order.
I'll bet you. It's fun.
All right, here it is. We got 2 copies there. As I reported, she was deactivated for failure to pay. This is on 3/7. To make payments. I deactivated her on 1/24. So I have not known about this for 4 months. She also would not charge her device properly. She called today wanting a new charger, stating that the reason she finally decided to reach out was because she had to be in court on the 28th. She says she still cannot pay, so we will not be continuing with her. And if she shows up today, we will cut our device off. Just wanted to make the courts aware. I'm not sure whose court she is on the 28th because she is out of both courts. You have another court case and another.
I don't know.
Every time.
This is kind of quiet. I have it turned up all the way on my end. I actually meant to boost the audio before I put this video out. I do apologize. The next clip, part 2, is louder, so we'll be able to hear that one better. But I don't know what's up with Judge Stevens' audio today. It's just really quiet. But Legal Fiction, 10 gifted memberships. Thank you so much, buddy. I appreciate it. Very generous of you. Thank you. And welcome to all the 10 new members.
I always have to come to this one, so when I make it to the other one, it'll.
What other one? Which other court do you have? She must have a misdemeanor. I'm looking right now.
I ordered on.
All right, I'll tell you guys what's going on. So she hasn't paid on her ankle monitor, her tether. She hasn't paid on it. So they haven't been monitoring her since January 24th, is what Judge Stevens just said. So yeah, she's wearing this tether that's not on. And she's still charging and everything, but it's not on. So yeah, she's kind of in trouble.
Misdemeanor cases that are pending.
I ordered on October 9th, 2023, that the defendant, as soon as possible, must have a GPS device. And so I'm learning on May 29th that she has failed. She was deactivated 4 months ago,
Is it active?
and I didn't know about this.
Do you have it on?
You can sit over there. You're in timeout right over there. Thank you. We'll deal with you at the end. Yep, we got other things to do, but your bond is revoked right this minute. And you sit in the jury box, please, ma'am. Thank you.
She got put in timeout. You were going in timeout. Go sit in the jury box. All right, so this is bringing her back up. This is actually, I guess technically this is part 2. And then I have part 3. I'll explain that a little later. But yeah, I saw a couple of people ask. It is her fault because she wasn't paying the fees for the tether. So you have to pay the monitoring company to monitor you. And that's court order. So if you don't pay them, they just stop monitoring you, and it's a violation. So that's what's going on. So for 4 months she's been wearing it, and yeah, with no luck. Chris Schultz, thank you so much. Good evening, Colin and Cromwells. Thank you so much for the 5 members, Chris. I appreciate it. Thank you.
I've spoken to my client a little more about this ankle monitor issue, and I think we have. So that's kind of what happened.
We got a problem. I mean, they state that it was deactivated 4 months ago. And where is your monitor?
It's on my leg, sir.
But it's dead, right?
Yes, sir. It is.
It's charged, Your Honor. I think she's charged. It's charged, right? Or is it-
I've been trying.
No, he deactivated, so it
Well,
doesn't matter. It's,
back in
you can
Jan-
get charged, you can use it as jewelry but it just doesn't do any purpose. It doesn't serve
I
any
think, Your Honor,
purpose
as she
otherwise.
has, I'll let you know kind of what happened in that time period.
Yeah,
Can she speak, Your Honor? Can you explain what happened?
yeah,
I've already talked to her.
this is your time because I'm about to make some orders that are gonna affect your freedom. Go ahead.
4 months ago, I was pregnant. I ended up being in a relationship with somebody. I didn't know them that well. Thought I do childhood, and Whenever time I did that, I was getting away from something. I went there. It wasn't the best situation. I ended up getting pregnant during that time. That person beat me. He tried to sell me, like sex traffic me. I was fighting. He beat me with.
How is
everything.
it somebody else's fault that you didn't pay for your ankle monitor?
was
How is
being-
that somebody else's fault, man?
I was being held captive at the time, like, and I
For
basically
4
had-
months, you've been held captive?
I didn't.
This has been deactivated for 4 months. Nobody does that.
He was. I literally had to scream outside the house for help in Dallas, Texas. You can look his name up. He's actually like.
Well, did you file on him for kidnapping?
Yes, sir.
What happened in the case?
Bruises. He's personally in jail right now because of this.
All right.
I have bruises. There.
Once again, but for 4 months, you haven't had a device that you were supposed to have. And that's your problem. You're charged with deadly conduct here. And there was a good reason that we made sure that we wanted to know where you were. And this happened where?
The incident or with this?
Yes, the incident, no, that you said that this person.
Dallas. I went to Houston with him. and
What are
he
you
took me
doing in
all the way-
Dallas?
He took me all the way to Dallas, and he took all my.
What are you
phones and
doing in
everything.
Houston?
That's what I was trying to explain.
See, that's why we have these devices, so we know where you are at all times.
Yes, sir. And during that time, like basically, he took all access to everything. I basically had to stand outside the house and.
You made a choice of who to pile up with.
You're right. And
That's your
I
problem.
left that situation, and so I was getting back, and I just never had a chance to pay. But I can pay today, and not only that, like I don't have no issue. Like my only thing is.
You got a big issue.
I don't like. I didn't do it.
You got a big issue on this order of the court.
I'm just trying to get past this. I can't go. Like I don't want to go through. Like I don't know.
That's where you're headed. I mean, that's
And
where
not
you
only
go
that-
when you don't follow the orders of the court. For 4 months, my goodness. I didn't know about this.
And the only reason why you put it on me just to make sure I wasn't late for court. Like I didn't show up for court, and I showed up for court. That was the only reason why you put it on me. I never been in trouble before. I ain't run.
It doesn't matter. The court can,
anything.
for good cause, any good cause, order bond conditions.
Yes, sir.
But
I understand.
but what you've told me is you decide when the bond conditions and what bond conditions are gonna be followed, not me, and I'm supposed to be the one setting it. But for 4 months, you have been violating a condition of bond, and then we kind of stumble upon it because we have so many cases, we can't be watching everybody. We have to trust that they're gonna follow the rules. And
And you-
sometimes it happens where you, a day or two, and there's no harm done, but we're talking about 4 months.
And I still followed. the
And then
rules.
you're getting involved in issues, criminal issues in other
No, I
counties.
didn't get involved in criminal issues.
You were
That's the
part
thing.
of something
No.
that was, you
I
said,
didn't do anything.
you wanna just continue to just interrupt me through this whole thing? It sounds like you're the kind of person though that kind of bullies your way into your way. You want it on your terms and when you don't have it on your terms, then you interrupt and you make excuses, but the bar is set for everybody and they have to get over the bar. And you hadn't been over the bar in 4 months. And that was something that you had an obligation to tell me as much as the bondsman did. But you haven't been following a condition of bond for 4 months, my goodness. That's serious. Very serious. And what we normally do in the cases like this is your bond is revoked. You're in jail and we'll sit this out until we can dispose of this case. That's what happens in all the cases. Sorry, but you had a chance. I have to be able to trust you and I don't. This is a big gap of a problem.
I think, Your Honor, the argument she's trying to make.
We're talking about a crime of violence that you've been charged with.
Didn't do it. It's no.
Well, you're presumed innocent, but the grand jury says there's probable cause to believe you did. Because of that, I have to rely on that as a probable situation. So that's why bond conditions are set. And that's all we're talking about.
Your Honor, I think the issue was because she got involved with someone who ended up being in a very violent, bad situation, who got taken kind
I'm
of.
talking about 4 months not telling me about.
Well-
That's what we're talking about.
Well, we don't, she just recently got free and that, so she was kind of held for him for a while, so
No,
that's.
no, when I can see that for 4 months she's been held she's been kidnapped for 4 months, let me know. But I haven't read about that in the paper, and that would make the news. Don't tell me that you hadn't in 4 months been, had time. And John, here's what we'll do, is I'll give you a hearing on it, and y'all can produce witnesses, but until then, she's, it defies logic that she has been held captive for 4 months. And I want to see some proof of that.
We'll get that going.
All right. All right.
We're gonna be in custody for now, so.
Your bond is revoked. Yes, because you hadn't had a monitor on it. You hadn't called me about it and talked to us.
Possible.
And it was deactivated a long time ago. That's your responsibility. It's a condition of bond, and you must have that, or you're not released, You must have that, but I've already, you're gonna interrupt me all day long. Is that what it is? Boy, that's rude.
No, sir.
I mean, if there was a crime for that, you'd be guilty of that one, because you interrupt. Anyway, that's what I'm gonna do, John, is those findings and see what y'all, I don't know what y'all plan to do in the disposition, but you can have some time, talk to her before we send her.
Absolutely. That's
away.
what I'm about to do.
But I've got to have some conditions that, so we know that she's supervised, and you're not being supervised by the court, and that's what you're supposed to be. And you were on your own supervision, which is not the way it works. All right, well, let me know. Thanks, John. We're here for business. Okay, who else? Did you have something?
Claudia Marks, she's outside.
All right. So that was part 1 and part 2. Part 3's coming. I've got 2 short ones, and then I've got part 3. I just kept this video together. You know what? I can pop up part 3. We'll just keep it all together. This is thanks to Lone Wolf, who just popped in. And yeah, you can tell that reason number 125 that he has a better channel than mine. His audio is a lot better. All right. Before we go further, Sparkle Poots, Twat Waffles president accounted for. Welcome to Twat Waffles. I know you're trying to get me to play the theme song. I know. Hold on. Thank you for the super chat, Sparkles. Legal Fiction with 5 more gifted memberships. Thank you so much, Legal Fiction. I appreciate it. Welcome to all the 5 new members. And Kay Bush with a $20 super chat. Thank you so much, crazy girl. Yeah, she's up there. Thank you so much. That's very generous, Kay Bush. I appreciate it. Thank you. All right, let's go to part 3. Let's see, we just added.
Thank you very much. We call 22398551,
See, already so much louder. Same court, so much louder.
the state of Texas.
You guys want to hear the all right. You guys want to hear the theme song before we start part 3? Let me pop it up. I feel like this is gonna be really loud after all how quiet that first clip was. Twat Wobbles! And there we go. The Twat Bubbles have assembled. All right.
Versus Bernicia
Back to the clip.
Lassard, who's present with her attorney, Mr. West, and the state's attorney. What do we, I don't have anything.
I'm trying to get it to you, Judge.
Okay.
Batteries are dead on every one of these tablets.
Oh, boy.
This is what,
I know, we're meeting with them tomorrow to go over battery stuff.
well, people aren't plugging them into when they leave here.
Well, that's also good.
22398551 is called. Does the defendant who's present with her attorney waive a formal reading of the indictment and the arraignment here? Can we proceed as such?
Yes, Your Honor.
In summary, this indictment alleges that on or about April 15th, 2022 in Jefferson County, Texas, you committed the 3rd-degree felony of deadly conduct. Do you understand what you're charged with here?
Yes, sir.
Yes. If convicted, you face no less than 2 nor more than 10 years
Yes, sir.
confinement in prison, and a fine up to $10,000 can be assessed for any third-degree felony. Do you understand?
Yes.
An agreement has been reached in this case. Can you read that into the record?
Yes, Your Honor, the agreement is a cap of 6 years.
6 years.
Yes, sir.
All right, so we're looking at no less than 2 nor more than 6 years in
Right.
prison.
Or probation, deferred probation. I think she's open to all of them.
Deferred or unadjudicated probation up to 10 years. What about regular
I
probation?
think she's eligible for regular probation too. She doesn't have
I can't remember. This is kind of a weird one, isn't it?
It's deadly conduct with the,
On
with
deadly,
the firearm, isn't it?
yeah, I know, but didn't we
If it
have
has a
that-
deadly weapon attached to it, can it be?
It's 3G. I don't
remember?
Hey, welcome, Nick. Good to see you. Thank you so much for the super chat. And hello to you as well, you beautiful person. Thank you so much. And I already forgot who asked it. Yes, it's the same day. The part 1 and part 2 both happened this morning. This happened this afternoon, all on the same day. But this is actually the case of why she has the tether on. And she's trying to plead to this to get out of jail. You know, she thinks this is going to work, but this is hilarious. Just watch.
Oh, registration was available. That is perfect. Sure. Who's not faster? Sorry.
No, this is the case for the reason why she has the tether on. So she pled to the tether. She didn't plead to the tether
It
violation.
says Article 42A53 does not apply to.
So this is why she was in court today. She had the tether violation. They were trying to adjourn it, and that's when it was discovered she had the tether violation. So her bond was revoked, and her attorney pulled some magic and got this case back in front of the judge for a plea deal. Just a couple hours later. That's what's going on.
The defendant will need to show that a deadly weapon is defined was used or exhibited during the commission of felony offense or immediately after. And the defendant used or exhibited a deadly weapon. So that's on the law of parties that wouldn't be.
Okay.
So 42A054, looking at subsection B.
Hold on, yeah. So, there was something weird about this in the past, the statute, but okay. Fine.
Under subsection B, it says it does not apply to a defendant when it's shown that a deadly weapon was used or exhibited during the commission of a felony offense or immediate flight therefrom. And then number 2 says, and the defendant used or exhibited the deadly weapon.
Mm-hmm.
And so this is not a law of parties. This is, we're accusing her of doing this.
Sorry. Well,
Yes.
No, it's just weird that it wasn't. I guess it didn't either. It wasn't specifically
Stated in there.
enumerated
Right.
in the numerical sequence of crimes. Didn't we have?
Because
That's
there's,
how we dealt with this issue one time, and we had a bunch of disagreement over it, but it clearly says any offense involving where the use of a deadly weapon, I mean, it wouldn't make sense. It wouldn't apply. I mean, I don't, the elements of deadly conduct certainly seem to be
All right, in there.
no less serious than
Because in the indictment.
a deadly weapon
Knowingly discharge a firearm.
was used or exhibited.
I guess there are ways on deadly conduct that you could recklessly engage in conduct that places another in imminent danger or serious bodily injury without using a deadly weapon.
Right.
So it's only if there's allegation of a firearm and that they use and exhibited one, a deadly weapon.
I think there's other ways to get deadly conduct without getting a deadly weapon. Which doesn't make sense.
All right, so it looks like those are the only two options. Deferred or
probation
unadjudicated.
for 2-6.
An agreement has been reached. Again, where whatever sentence shall not exceed a cap of 6 years in prison. And is that your understanding of the agreement? If I follow this, you have no right of appeal of your case. Do you understand? How do you plead to this indictment charging you with the 3rd-degree felony of deadly conduct, guilty or not guilty?
Not guilty. I mean, guilty.
You got to pick one.
Not guilty. I mean, sorry, guilty.
What's your, think about it, relax. Okay, what is it you're going to plead? You've pled not guilty twice.
I have to plead guilty, so you there's me a
Are you guilty or not guilty? That's the question. Okay, all right. Well, that's okay. Yeah, you can't force you into this. All
I'm
right.
guilty. I mean, guilty. Sorry.
Oh, no, this is,
Judge, I
I'm
don't,
guilty. I didn't understand the question. Sorry.
what did you want to say, Mr. Lane?
Judge, since she's pled not guilty twice, I just wanted to make sure she had time to think about it, not just make a rash
Yeah, I
decision.
thought there was a decision made and we were over lunch.
Yes, sir.
and
Right.
Then came back.
Sorry.
That's
Man.
good.
Guilty.
Okay.
I'm positive. I'm 100% sure. Judge Stevens. Sorry about cutting you off.
So how do you plead then?
Guilty.
Is that your final answer?
Yes.
Are you pleading guilty voluntarily and because you are indeed guilty of what this alleges?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1.
Oh, you think that was the hard part? The whole guilty, not guilty part? Nope, that's not the hard part.
And did you sign that
Yes, sir.
voluntarily?
Yes, sir.
Understand it, discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into it.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. And you've thought about it, and you are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived?
Yes, Your Honor, I think it will.
Okay, I want everybody to
If that's okay.
sound in on this.
Yeah.
What?
Yes, Your Honor, I think she wants to move forward today and not do a PSI.
Okay, go ahead.
Your Honor, I would request, in this case, my client give deferred probation. Some of the reasons why is that she has no criminal record. She had this, I think she has some pending misdemeanor charges that may be related to this or sometimes after that, but it's not. She has no convictions for that. So the fact that she has a clean record, this was a disagreement regarding her her child's father, however you want to describe him. She apparently had a dispute with him. A gun became involved. She had a gun for her protection. And then somewhere along the way, there was a shot fired. Luckily, no one was hit with the shot. She has been cooperative in court, even though, like I said, this morning we had an issue regarding the ankle monitor. She was here to be on court on time here, didn't have any issues there. And I think I'm looking at here, the other misdemeanor is pending as evading arrest or detention. I think when the cops got there, she did take off running from them. Or I'm not sure the fact that I know she was charged with evading arrest and detention as part of this offense. Your Honor, this is the case where we were here this morning and her bond was revoked. She, at that point, said she wouldn't have taken the deal. We were kind of working on a deal with the state.
It was revoked because of this.
Ankle monitor, yes, absolutely, yes.
Ankle monitor.
But prior to that, me and Mr. Laird started negotiating a deal on this, and we were going to reset it for a little more time to negotiate a little further to try to get her. I was going to request from the state probation, and I think that's why Mr. Laird did offer the cap, whereas they were not going to agree to probation, but they were giving her the ability to get probation from the court. And we just asked the court to give her probation and what are conditions the court thinks are required to make her successful.
Okay. State.
Judge, the problem I have with all that is the use of a deadly weapon. You know how this county is just turning into just one place after another where everybody's using a gun, and nobody ever settles their fights with words or anything else. I'm trying to remember. I mean, there was a lot of things going on out there. It looked like there were a bunch of people, but witnesses all backed up the complainant in this case that she also had her children in the truck and pointed it at a group of people. And I think she actually fired one shot at the group. When they got to her, she had 3 outstanding city warrants, of course.
How'd she miss the group? We can't hear what you're saying.
I never shot. I never had a gun. I asked them right there to test me for gunpowder residue. They didn't, and they had cameras and everything. And the police even said they didn't see nothing. The only people who said that I shot was his recent girlfriend and his childhood best friend. I was in the car. Everybody else can testify and said that I stayed right by an apartment. The incident happened right by the park. I never had a gun. I promise.
All right. The defense attorney just closed his laptop. What do you guys think just happened there? She pled guilty to something, and then she's like, oh, I didn't do that. I promise you, Your Honor, I didn't do that. They had cameras. I asked them to do all this. They didn't do it. Like, you just pled guilty to this. The look on everyone's face right now is all the same. Like, guilty, not guilty. No, guilty, not guilty. Not guilty. Guilty, not guilty. Okay, I'm guilty. I did it. No, Your Honor, I actually didn't do it. Yeah. How do you think this is going to end up now?
Mother Grady, I'm passed away.
Well, then how did we get to
Shot fired.
how did we get to this charge if you didn't have a gun?
You know,
Well, but you just pled guilty under oath saying you had a gun, that you threatened these people with firearms.
You're in a catch-22. I mean, this is what the crime is that you just pleaded guilty to. And you knowingly discharged a firearm in the direction of a person. And that's one of the elements of this crime. That's a problem. You either admit it or you don't. And if you don't, so
If you didn't do it, now it's time to fight.
I didn't do it. I didn't shoot again. I promise.
Okay, well, we can't go forward with this. All right, well, then, what we'll do is, well,
Yeah, he had to finagle a few things to get her back on the docket to do this plea hearing while she was in jail for the chance that she would get out of jail today by pleading guilty to this. Yeah, it did not go that way. But he did rush it. He rushed this. And, he was trying to help her, I guess. I don't know. Let's finish this clip, though.
the bond is revoked. And we gotta, I told you what the bond is, and it's gonna be doubled and she'll be held in custody. But all we can do is put this up for trial as soon as possible and set it for trial. Whatever, everybody says.
I can disagree. I can disagree. Just do probation. I just don't want to go to jail. I really don't. I agree with it. I just don't want to go to jail. If I could just do probation, I accept all the penalties. Yes, please. But I think I just didn't shoot again. I didn't shoot when I didn't do anything. I asked them right there to text for gunpowder residue. It's everything, even the police, like the cameras, all of that.
I'll look at it, Judge. I promise I'll look at it really hard. I promise.
Well, I mean, but of course, the only other thing is a no contest plea,
Please, no contest. Yeah, that's what I want to do. No contest.
but they gotta agree.
Yeah, it's up to the state.
Now, here's the problem with that is,
They never do that.
if you're honestly saying you didn't do it, okay, that's what's gonna be, because nobody else has told you this. If you mess up on your probation later, you can't come back and say, I didn't do it, you'll go to prison, okay? You could go to prison on mess up, well, you say that now, but there's a lot of things that can trip you up.
I'm gonna try my hardest.
So- If you did not do this, now's the time to say that, and I can look at it, I'll look at it again and talk to people, we'll see. I don't want to take a no contest plea, because you really seem adamant about the fact you didn't do it.
But I also don't want to sit in jail. I get this probation. I sit right here and take.
Right now, that you can't enter the plea. The state doesn't agree to it. So we have a bond issue that's gotta get dealt with, so.
Yeah, I already had him, I know somebody filing a bond,
I do not.
notice of bonds, request to respond. I'll file that soon, and we can have it on here.
All right, but right now the bond is revoked
Haven't
and
prepared yet.
for
Yeah.
failure to maintain the bond condition of having a GPS device as required. But I can bring her back, you know, next week.
Every week.
When y'all, as soon as y'all can figure
I
something
think
out.
except for the week of July 4th, is the only I'm not here. So
All right,
I
that is,
am,
that is all.
I am number 2 this coming Monday next door.
Okay.
But that'll be at 1 o'clock, so I'll be Monday morning.
Okay.
I'll sleep guilty. I just don't want to go to jail. Can I do that right now?
No, you can't do it now. You've already said enough. You kind of put yourself in a bad position. You can't,
I'm sorry.
Trust me, this will be better.
all right, what's next?
Come on.
Should have learned, man. Before I go back to.
We treat you like we treat everybody else. We don't have a GPS device for 4 months, you kind of lose your bond. Mr. Wilkerson?
All right. That's the end of that one. Now I'm gonna put up the rest of the, the premiere that was gonna happen. And yeah, thank you so much, Lionel, for sending me that. This is awesome. I'm glad I got the this clip. Yeah, I saw the first 2 this morning. Didn't go back to his PM docket. So Lone Wolf's awesome for letting me know this. All right, back to this one, and I'm gonna watch Judge Stevens throw a few people in jail.
On this, were you getting an attorney? Who's your attorney? Mr. Adams? Okay. You flunked your drug test. You've got marijuana in your system, tetrahydrocannabinol. What's the bond?
$30,000.
It's revoked. It is now $60,000, plus you must have a drug patch as a condition of bond. You will be taken into custody. We will alert your bondsman, your attorney.
That's me.
What do you want to say?
I just got out of state jail and I haven't smoked since that was when
Well, the scientific test says you have drugs in your system, and that's what we rely on. It's not a debate. You're in custody. It's not a debate. The scientific test says otherwise. Here.
Yeah, this next one is short too. I think this guy fights a little harder back though.
How you think you did on your drug test? You failed. Yeah, you're revoked. You got amphetamine and marijuana in your system. Donald Baker. Donald Bates.
Bates.
Bates, it looks like a K. It's Mr. Bates on,
$20,000.
okay, your bond is revoked. It is doubled to $40,000 from 20 to 40. You must have a drug patch as a condition of bond.
A drug patch?
Yeah, because you flunked the drug test.
What is a drug patch?
It tests your system at all times. It's something that you have to wear.
Well, can I wear that out there? Cause I work every day.
Yeah,
Like-
people work and have the drug patch. You can't see the drug patch.
But that's what I'm saying. Can I get it? Can I still have my bond and still?
Your bond is revoked. It is now 40,000 because you violated the bond conditions. You just committed 2 crimes. These are crimes of illegal. You haven't heard of the drug crimes? Yeah, it is illegal to possess marijuana. It is illegal to possess amphetamines. You have it in your system.
I had my system when I got locked up.
Your bond is revoked. It's $40,000. You have to have a drug patch as a condition of release. That's what happens when you fail drug tests. You're taken into custody. Those are the orders of the court. Thank you. Who's next?
Oh, he dropped a little attitude when he was walking out. I missed that earlier. Drug patch. I have had to ask this question too. It's like how I understand it. I could be wrong, but it's kind of like a nicotine patch. But what it does is it reads your sweat, and it'll detect if there's drugs in your sweat, and you have to go every so often, like once a week, to the probation office, and they'll take the drug patch off, put a new one on, then they'll test the drug patch. That's how I think it works. All right. Now, since that was the video that I was going to play as a premiere earlier, now I actually got to load the video that I made for tonight. Should have done this before the stream started. Oh well, it's only 2 seconds. Yeah, this one. I'll fast forward the intro. Now I'll fast forward it. Start with some Judge Boyd. All right. I don't think there's any Judge Stevens in this video, so we are Judge Stevens free for the rest of the night. But thank you guys for hanging out. All right, Judge Boyd, let's go.
This is the one I was telling you about.
Mr. Backfill, are you all going to withdraw your motion or no?
Yes, sir.
All right, Mr. Backfill, you were placed on probation.
Yes, ma'am.
And you haven't been doing well. Why not? Unfold your arms, please.
The information that wasn't correct.
All right, everyone, please whisper.
The information wasn't correct, so.
What information wasn't correct?
No, I guess when they couldn't get in touch with me,
All right, so your information was not correct?
I guess the number was wrong.
No, I mean, it's not its guess. Either the number was right or,
Wrong. It was-
all right. Didn't you hear what I just told him about honesty being the best policy here?
Yes, ma'am.
So where have you been staying?
At 6746.
I mean, who are you staying with?
Yeah, I just use it as an example of like what it might look like. It doesn't put. Yeah, I know that the nicotine patch, helps you curb your nicotine addiction, but I was just using it as an example of what it could potentially look like. That's all.
Sister.
I'm sorry,
My
who?
sister.
Does she have any children in the house?
Yes.
What are their
Over here,
ages?
child. Can't remember his age.
Well, is he in school?
Yes,
Is he in elementary school, middle school? I'm sorry, what?
he's in junior.
I can't hear
He's
you.
in junior.
Junior high? Okay. So if you drug tested today, what are the results going to be?
Should be clean.
All right, we're going to drug test you today. Is that you're still saying it's going to be clean?
Yes.
All right. Ms. Abrams, if we could have a drug test for Mr. Bearfield. All right, just have a seat. All right. On Darren Doe's,
Oh, I forgot to fade in and out. All right, here's the thing. Here's the thing. If you're in front of a judge and you're on probation for anything or bond for anything, you're in front of the judge and they ask you what's in your system, be honest. You know, maybe if you say, "Oh, I'm clean," maybe they'll just trust you and not drug test you. But no, they're most likely going to drug test you. I wouldn't roll the dice. If you would have said, "Hey, I'm going to be dirty for this, this, and this," but I've been clean for 2 weeks. I don't know how long it stays in my system after the last time I used, but I did fall off the bandwagon. That's a better story than just say I'm going to be clean. All right, you can even look at Judge Boyd's face right now.
all right, how often are you using drugs?
It's been a month.
No, cocaine doesn't stay in your system for a month.
It's been a month ago now.
I'm sorry, what?
A month ago.
Cocaine, what I'm telling you is cocaine doesn't stay in your system for a month. So your whole thing about I used a month ago, that's according to the test, that's not true. So again, we're back to your level of honesty, and you need to be honest with the court. So how often are you using drugs and what are you using?
How often am I using them?
Mhm. No, I'm not with you, so I don't know how often you're using. I don't even know what your idea of often is. So how many times are you using per week?
Once a week.
All right, so you're using once a week? Is this on the weekend or is this during the week? All right. And where are you using?
Huh?
Where are you using the location? Are you at your sister's house? Are you somewhere else? Where are you when you're using?
Like walking to the store or something. Not at my sister's.
So we have, yeah, this is where we are. All right, just have a seat in the box for a moment. Yes. Can you mute us, please?
How long did I keep this going for? Let's
To
just
give
go.
you a chance.
Oh,
I
we
want you to
skipped
get
ahead?
healthy mentally and physically.
Yes, ma'am.
So this is what we're gonna do. We're gonna take you into custody. Oh, here's
Sir, is there a reason why you can't be quiet? Quiet down, please. I'm not gonna tell you again.
okay, so here's the thing. Here's the thing. If you were revoked, you could be going to the state jail facility for 2 years. Everybody's trying to help you with your drug issue. So I know it may seem like a long time to you, but it's not 2 years. It's going to be 2 weeks. Probation is going to help felony drug court see if you are a good candidate for their program, and they're going to do a TAP evaluation. Then we can figure out what would be the best treatment plan for you. Do you understand? Yes or no?
Yes, ma'am.
All right, so the state is telling me they're going to withdraw the warrant. They're going to withdraw the motion. And what I'm going to do is alternate amend your conditions for a TAP evaluation and felony drug court in custody. You understand? All right, good luck to you. All right, could I see another?
All right, all right. I'm not gonna lie to you guys. I have no idea what the next cases are because I got excited about the Judge Stevens clips, and yeah, I put this together before I put together that, so we're gonna find out together. Oh, yeah, this one's from about a week ago. It's fun. It's fun.
Sir, are you James Wayne Rogers?
Yes, ma'am.
Okay, it looks like well, I would be guessing that maybe you had a sentencing and scheduled in front of your
On the
judge that you didn't appear or something.
No, my sentence is on the 3rd. Next month on the 3rd.
Well, it looks like you post a bond, so I don't know why you're back in custody.
Me either.
So unless your bondsman thought you were a risk and decided to turn you in,
My bond is only $100.
do what?
I said my bond is only $100. That's what I ain't, you know, and I got a job, I'm working. Staying out of
Anybody know why he's in court today by chance?
I haven't looked at his charges, Your Honor, but I know his bondsman brought him in, Friday.
Yeah.
Did you not pay him his $100?
Yeah, I gave him his $100 as soon as I got out of here. And then I started, 2 days later, got me a job working at McDonald's, doing good at McDonald's.
Where do you live?
I stay in Augusta. 730. And I work from Saturday, Sunday. I work into Wednesdays, and I'm off on Thursdays and Fridays. You know, so
Can anybody verify Don Kirkman's number? I can't tell. It's 323.
what I was
Okay. It doesn't matter. He thinks he has some reason that he could put you in jail, like you were gonna run or not show up or something, but he has to get an order from a judge that allows him to get off your bond. He can't just dump you in the jail and not go in front of a judge to get discharged. Unless you fail to appear, then he has every right to pick you up and put you in jail. Did you have a court appearance at some municipal court that you missed or something?
No, ma'am.
Okay, I need to find Don Kirkman's number. 3230. I can't read the bond.
Our booking corporal here, Your Honor, said a bond revocation.
Yes, I'm sorry. I'm trying to locate AAA
It's
bond and surety company, but it sounds like I have the wrong number.
005.
I'm sorry. Thank you. Bye. Okay, so
Could you imagine being the person that received that phone call? Hi, this is Judge so-and-so from the district court. I'm looking at, and my heart would just be like, wait a second, what? I thought Judge Middleton is the only person that actually called people from the bench.
I think it should be 316-311-16 is AAA Butler County bail bonding.
We have 3230.
okay. I thought it was a 4. It's a 6. Okay.
I've never had to mute so many phone numbers at one time ever. Stop saying phone numbers back and forth.
Did you pick up new charges?
No, ma'am. All I was finna do is go to a funeral and come back, and boom, I sit here.
You went to a funeral?
I was going to a funeral, and I got picked up.
Were you going to a funeral out of state?
Yes, ma'am.
And did you have a written agreement with your bondsman that you were not to leave the state?
No. I had no agreement or nothing.
Okay. Well, that's probably, he heard wind you were going out of state, and that's probably why he picked you up and put you in the jail, because that's between you and him, but we'll have to figure it out. So we need to get a hold of Don Kirkman, because the only thing they can legally, automatically, by law, turn you in and walk away is if there's a bond forfeiture bench warrant. Otherwise, they've got to bring information under oath in front of the judge to be discharged from the bond. So this is Judge Crumb's case. I'll just have to go talk to Judge Crumb, and we're gonna have to try to get a hold, maybe there's an order for discharge sitting in his queue or in his office.
There's not, Judge. I already looked to make sure.
Okay.
And the note
So-
does say not to leave the state, from Angela, from their evidentiary hearing, but I'm trying to call Don Kirkman now.
Oh, he's not to leave the state? Well, that's why you're in there, but they still need to get a discharge. You're gonna have to talk to Judge Crum about this. Okay, so so I guess we'll set your case.
I know I go to court on the 3rd. That's what, next week?
Well, that's 2 weeks away, actually.
And Judge Crum has a first appearance on May 28th, which would be Tuesday next week. Would be his next
Yeah.
first appearance at least.
Well, I'm just gonna give Judge Crum the information and set your, I don't know what to do on a bond. He's gonna have to decide what to set your bond at and what to do. But I'm gonna schedule you in front of him at 1:30 on May 28th. You're still scheduled for your June hearing, but I want to get you in front of him as soon as possible, okay? Okay, I'm sorry, sir. That's why you need to always ask permission, like you should have asked for permission from the court and from your bondsman to go out of state even for a funeral. I'm sorry.
But even though I didn't go,
Well, I know, but they were afraid that you were going to. I'm sorry. It's gonna have to be resolved with Don Kirkman and Judge Crum and yourself. And do you have a lawyer? Let's get a hold of your lawyer right away. They can figure out what's going on.
I'm my lawyer.
Bill Fulgray.
All right, get word to Favre right away that he needs to contact Mr. Rogers in jail, that he got turned in on the bond. So hopefully Mr. Favre will work on it too. So that's all I can do today. I'm sorry.
Because he told me that since my bond's still $100, I can get another bondsman.
Well,
Couldn't
I
use
mean,
him.
technically, yeah, your bond hasn't been revoked. It's $1,000. If you can find somebody else that will post $1,000 bond for you, you could do that. You could do that, yes. And if you do that, then your court date will still remain June 3rd,
Same,
not the
right.
28th. But if you don't make bond, I want you to get in front of the judge, and I want Mr. Favre to touch base with you and figure out what's going on and acknowledge that you're in jail. Okay, sir. Thank you.
Thank you.
All right, yeah, that one was just strange. No one really knows why he's in jail. He's not supposed to leave the state. What I'm guessing happened is, you have to check in with your bondsman, I don't know, once a week. I don't know. But whatever he's scheduled to check in. And I'm going to guess that he said that I'm about to go to this funeral and it's out of state. He's not allowed to leave the state. The bondsman just went and picked him up and took him to jail. That's all I can think of. And he doesn't even know. I mean, I would think the bondsman would have told him. All right. Same boat. No idea what's next. No idea what's next. Oh, this is yeah, you'll see.
79 and 235-180. The record should reflect that Mr. Shepherd is present during the courtroom today.
Sierra Coke on behalf of the people.
All right, Mr. Shepherd, this is the date and time set for sentencing hearing in this case. You're appearing before the court today without an attorney. You understand that you do have the right to have a lawyer present?
Yes, I do.
And that if you could not afford a lawyer, one would be appointed for you at public expense.
Yep.
You wish to proceed on your own or
Looks like I'll be doing it on my own.
All right, have you had a chance to go through the pre-sentence report and review that?
Oh, no, I haven't.
You provided a copy of that? Did you get a copy?
I don't think so. Is it over here?
Mr. McDowell?
It was emailed to Mr. Shepherd at the email address that we had correspondence to. I don't have the exact date, but I go look at the computer if need be.
Did you ever check your email?
Oh, yeah. I never received one, but does the court have the right email? I don't know.
I have the email that we were corresponding with back and forth multiple times.
All right, so
I don't have
the email that you've talked to Mr. McDowell on before?
Do you know the email so I can confirm it is the right one?
I don't know it off the top of my head. No, I mean,
Do you have an extra copy, Mr. McDowell?
I'll give my copy.
Shepherd, we're gonna take a break for about 10 minutes. I'll give you a chance to review that report, okay?
Good, sound good.
Yeah, it's 1:36 or, yeah.
All right. Just to let everyone know, this isn't a good guy. That's why this is in here. Bad guy. Not like, hurting kids or, doing anything like that, but you're about to hear it. You're about to hear it.
And for the record, Mr. McDowell provided the court with emails that he corresponded with Mr. Shepherd regarding the pre-sentence report. And Mr. Shepherd, it appears you were mailed that report back on May 2nd to DB.
That's the incorrect one, and I've changed it 3 separate times in this court.
What's a diorama? Ralph. Oh, Ralph.
Yeah, well, as of April 12th, you were communicating with Mr. McDowell on that email address.
I have no access to that email.
Did you tell him after that you had a different email address?
No, I corrected it at the front office, so I figured it would have got to him.
Who did you correct it with?
One of the clerks at the window.
What was her name?
Not really sure.
What date did you correct it on?
It was, what would I have to say? Be my pre-sentencing trial. I guess whenever the last time I was in here.
When would that have been?
Not sure.
All right, well, if you can't give me a date, then I'm gonna assume that we have the correct email address.
Okay.
And as of April 12th, you had responded to Mr. McDowell from that email address. And he sent it to you at that email address on May 2nd. So, did you have a chance to review that pre-sentence report?
Yes, I did.
So, the way that this works is you have an opportunity to correct any factually incorrect information that's within that report.
Okay.
So is there any factually incorrect information in that report?
In that 10 minutes, I didn't get a really good look at what the report said, so I couldn't tell you if there's anything that was incorrect.
Okay, so you don't have anything to correct from that report?
Nope.
All right. This would also be your opportunity to challenge the scoring of the guidelines. Do you have any challenges to the scoring of the guidelines?
No, I do not.
Let's hope people have any additional solutions to correct.
No, and I believe it was scored properly.
Do people have any victims that wish to address?
Mary Elliott is present today. She does not want to speak. She did just have the victim impact letter that was provided to the court.
Okay, and for the record, I did review the victim impact statements.
They haven't said yet. You're about to find out. And when you're facing jail time, get a public defender. This is a sentencing, and I feel like he's just trying to prolong this. Oh, I haven't seen this. The report, the PSI report. I haven't seen this. And instead of adjourning, the judge is like, "All right, I'll give you 10 minutes." He was probably like, "Oh man, I thought that was my go home. We're gonna do this next week thing." Yeah, get an attorney.
So I did have a chance to read that. Sorry. Ms. Koch, anything on behalf of people for execution today?
We prepared for trial in this matter, and I took the video of Mr. Shepherd that was taken from Miss Elliott's ring cameras. And I watched him come onto the property and literally just start smashing her property for no reason that you can see it all. He literally walks on, you hear a bunch of crashing, you can see him in the different cameras, just breaking things and then leaving. You know, the restitution amount in this case is $5,340. And I can't imagine that Mr. Shepherd thought to himself the amount of damage he was doing to this woman's property, as well as her well-being and her happiness in terms of coming up here. She indicated she used to love coming up here. So I don't know what his motivation is to go to his neighbor's house and just start smashing things. And then, you know, it escalated into an R, you know, and stuff. Mr. Shepherd's 29 years old. He has 3 misdemeanors. He seems to have problems with self-control. I hope that he's able to get them under control. Otherwise, we're just going to keep seeing him over and over. The recommendation here is for 90 days in jail with 13 days served and restitution of $5,340.96. I'd ask the court to follow the recommendation. Thank you.
There you go. Now you know what he did. He was charged with Hulk smash. Not a good look, man. Not a good look. Unless you're giant green and you're saving the world from aliens. Hulk smash isn't a good look.
No comment. Do you have any explanation for why you did what you did?
An explanation? No, but I do have an apology or regretful. I am regretful for everything that brought us to this moment.
In the report, it says that you thought that that cabin belonged to you. Is that correct?
I did believe it belonged to me.
What in the world would give you that indication to buy it from somebody?
Did I?
Yeah.
No. I thought it was in my wife's name.
Okay. Did she have any kind of documentation to show that she owned that cabin?
Nope.
So what did she told you that she owned it, so that you decided to go?
I never seen any documentation on it.
So what made you think that you had the right to go on that property and do anything?
I would say nothing.
That, nothing. Ridiculous. Willfully destroy somebody else's property. With absolutely no explanation, no rational explanation. Doesn't make any sense to me. I was asking those questions because I'm sure Ms. Elliott would like some kind of explanation.
Right.
Apparently you don't have one. Apparently that's just the way you conduct yourself. I think given your record, which is minimal, you are, I think, eligible for probation. I think it's a reasonable step to take at this point. I agree with that further recommendation. I also agree that some jail time is appropriate given the nature of your conduct and really the lack of any kind of rational and reasonable excuse for doing what you did. Destroying somebody else's property that clearly didn't belong to you. So the court is going to also impose some jail time. I'm going to hold some jail time in abeyance to see how you do on probation. Frankly, the way that you conducted yourself during the pendency of this case, I don't hold out a lot of hope that you're going to successfully complete probation. Maybe you will, that'd be great. But if you don't, I want you to understand that there's going to be additional penalties and consequences for your failure to comply with probation. And you're not starting off on a good foot. You know, this whole, I changed my email, but I don't know when. And I didn't get this PSI when clearly it was emailed to you at an email address that you were obviously using almost right up to the point that it was sent to you. Again, that's part of what gives me concerns about your ability to comply with probation. My about not getting an email. Clearly did or should have gotten. Be that as it may, we'll see how we do. As to file number 235179, which is the resistant obstructing charge, the court is going to sentence you to 90 days in the Crawford County Jail. You have credit for 13 days served. The court is going to order a crime victims assessment of $130 and a $68 state cost. As to file number 235180, malicious destruction of property, the court is going to place you on probation for a period of 3 years. The court is going to adopt as the conditions of your probation, all the terms and conditions listed in this report. So it's very important for you to go through those with Mr. Valdez so that you understand all the conditions of your probation. An excuse later on if you didn't know or didn't understand. So whatever you need to do in terms of asking him questions to make sure that you're clear on all the conditions of your probation, you need to do that ahead of time. Because again, once you sign that order of probation, the court's going to assume that you know and understand all the conditions. The court is going to, on that file, order that you serve 180 days in the Crawford County Jail, 90 days of that up front, with credit for 13 days served. The court's going to hold 90 days of that in abeyance, served at the discretion of the court. The court is going to order restitution in the amount of $5,340.96 to be paid to the Crawford County Clerk, be dispersed to latitude and subrogation services. Crime victims assessment of $130, supervision fee of $30 per month while you're on probation, $325 in court costs, and $8 state costs. The court is also going to add to the conditions of your probation. It's already part of the conditions, your paragraph. It should be 21, which is you must not enter the property located at 11523 Hardin Road, Roscommon. The court's also going to add a no contact provision of victims in this case. So you are to have no contact either directly or through another person with this Elliott while you're on probation. You have the ability to seek an appeal of this sentence, and Mr. Trush, if you wouldn't mind, I'm just having showing Mr. Shepherd where he's here now and see that those grades.
Yeah, this guy doesn't care at all. No care. He just walked onto a property and just destroyed a bunch of stuff. Luckily, they had cameras. Could you imagine coming home to that and not knowing anything that happened? All right. I was just about to fast forward the rest of this case, but you know, we love a good perp walk. We're gonna see one.
Statement, Mr. Shepherd explained to you what your appellate rights are, as well as how to request a court appointed lawyer to help you with it. Remanded to the custody of the county at this time.
And Your Honor, I just want to place on the record so Mr. Shepherd's not surprised. If he violates a condition of the probation, he'll have a probation violation. But it's also an additional charge of aggravated stalking if he goes on that property or has contact with the victim. And I will have no problem charging that if he violates. I just wanted him to know so that it's not a surprise later.
All right.
I love that the prosecutor just had to say that on the record. It's kind of like a threat. Do it. Just go. Go step on that property. I want you to get so much more than you just got punished for. Yeah, I call him a kid. What they say, it was like 29, I think. Just no care in the world. No remorse, nothing. Kept saying no comment. Why'd you do it? I don't know. No comment. Idiot. All right, what do we got next? Oh. What do you... We're at an hour and 15 minutes. We're only halfway through the video because I played the Judge Stevens clip. Yeah, we still have a lot to go. So I'll play this one, but we might cut it after this one. So this is just a woman that has 1,000 excuses. It's one of those, nothing's my fault types of defendants. So it's, it's fun.
380262790 for the record, Sean Parent, present Malmberg.
All right. Good morning, Ms. Malmberg.
Morning.
All right. If Skizrock is just listening and not watching, then you know I gotta play his theme song. All right, just for you, Skizrock, just for you. All right, back up to the video. No, no, don't. Oh, is that your way of trying to say that you want me to play the entire video? Is this muted? Why isn't there any sound?
All right, looks like you were
Oh,
picked
there we
up
go.
recently on a theft of a motor vehicle. Everett Division.
There's a dismissal date on the 31st.
Okay, you have a few active warrants from
You gotta earn it, Jason. You gotta earn it.
Marysville.
And that didn't mean you have to buy it. That's not what I meant by earn it.
And I know that the last time you were in court, we were talking a lot about how you had been in Bothell Municipal Court and Judge Rosano had given you some opportunities, and I also wanted you to do well. You were to enroll in electronic home monitoring. And you got out of custody and we didn't see you again.
I honestly did call and try. I promise you. I called the company and they said they were closed. I believe it was on New Year's is when I was supposed to call. Because they were closed for holiday. And I got out after Christmas before New Year's. So if I'm
We're out on the 29th of
okay,
December.
so, yeah, and I think I had 48 hours or so to be in compliance, if I remember right. And then I called and they said there was nothing they could do for me, that the business was closed. There was no one to talk to. It was somebody in some other state. It was just like answering machine service, like an actual person, if you will. And then so I called, I'm sorry, I forget his name.
Mitchell?
Yeah, Mitchell. I called him, I texted him. I called him several times. I was freaking out because I finally was doing the right thing. I laugh because it's stupid. I really was doing the right thing and nobody could help me. And it was so frustrating. And so I left him messages after messages. And then I finally texted him with, please, if you can't get a hold of me on this phone, call my mother's house, leave a message on her cell phone, leave a message on the house phone. She will get to me. She will give me these messages. I don't know what to do because I'm not in compliance. I know I'm not in compliance because this company's closed. It's already been the due time she gave me from getting out, and I'm not in monitor. I'm not at home with my mother, and I'm not doing my 45 days. So I was so frustrated. And then my phone got stolen. And then I just lost all my hope went down. It did. I promise you, I know you have a lot of faith in me and you've given me a lot of faith that I'm going to do this. I feel right now that I'm in a lot better position than I have been finally. I have 2 cell phones for that matter. Me and my boyfriend both got cell phones from the government. So now I have 2 phone numbers that you guys can get a hold of me at. If one is dead, one gets stolen, you can call the other one. You can get a hold of me. You can get a hold of my mother. Me and my mom are on somewhat decent terms. And I've been working for her and actually painting her house and doing stuff around the house to try to get back on my feet. And I'm hoping that me and my boyfriend sometime soon, before at least the fall, can get into housing somehow. So I've got a lot of good things going. It's just starting. I'm glad I'm here. in front of you again, because I'm hoping for a one last chance with you to get going, and I would like to just get through the time and then get going. When I get out of jail, I have 48 hours to be in compliance with Montlake Terrace. So, and that goes to go for every city that I'm in trouble with, it's the exact same thing. I have to do a drug evaluation and I have to get in compliance and probably go to treatment. So I have every intention on doing that with Montlake Terrace as soon as I get out, which means I will be in compliance with you and I will be in compliance with Marysville and I will be in compliance. And then I will have my other 2 court dates that I have going on taken care of in the meantime.
So she wants that one last chance. You know, the one last chance you get after your other last chance. So this last chance will be the last chance. That's what she's asking for. She's got a lot of last chances. How do you get that many last chances? I'm lucky to get a second chance.
Long-winded, but.
Well, I saw there was some information that maybe there was some assaultive behavior last week in custody,
No,
that you were switched to maximum.
no, that's
No.
not true. What? That's not true whatsoever.
We tried to transport you on the 13th and we were.
Oh, you know what? I think I was sick. Is that what they're saying?
That was the information we had, that you were unable to be transported.
That's really odd and it's very untrue. Very, very untrue. Do I seem like somebody that's gonna do that? I'm mind my P's and Q's when I'm in jail. I don't want to go to the hole ever. I'm very, I'm actually, I have right now, just to tell you, I have a paperwork in to be a module worker right now. So if that was true, that I had assaultive behavior, they wouldn't allow me to do that.
I'm going to hear from Ms. McDonald, the prosecutor, on how she wishes to proceed.
All right, I'm gonna call bullshit on her story, and here's why. When you say things like, "I'm about to be approved of this," and if I did what you're saying I did, I couldn't be approved of this. Well, you're not approved of it. I mean, also, using something else to say you didn't do the one thing you're accused of doesn't work. You know, just say, no, that's not true. I remember that day. This is what happened. Didn't assault anybody. That's better. That's a better approach to it. No, I was sick. If I you know, I punched a guard in the face, then I would have got charged with it. I didn't get charged with it, so I didn't do it. So it's not true. That's not what she did. I'm just saying.
Well, Your Honor, I think we have the issue that she didn't complete the 45 days of EHM. We also have the issue that the reason the 45 days was revoked is because she hadn't done the chemical dependency evaluation and treatment. So I don't see that we have that either, or a plan for that, or steps towards that. That's something that I haven't heard this morning. So if there could be an update on that respect.
I just said. That's what I was just saying, is that as soon as I do that and get out, by the time I get out, I will be in compliance with you guys within 48 hours, because I already have time served with Montlake Terrace, and they told me that within 48 hours, I have to be in compliance with them or I'm gonna have a warrant again. I do not want to do this all over again. I'm done with it.
No, but what I'm looking for is, do you have a treatment agency lined up? Do you have an evaluation scheduled?
I don't have the evaluation scheduled. I have had an evaluation with Marysville when I was in custody within the last year. So I have had one evaluation. I haven't had an evaluation with you guys since you have told me I need one. I'm sorry for that. But I'm thinking I'm going to end up going to the diversion center, is because it's really simple to get set up there. And I can get that all set up in jail with the scout program that they have. So I'll be able to kite the scout program and they'll be able to tell me the right way to do things. And then I can go to the diversion center. after I get my evaluation done. And they can actually do my evaluation, I believe.
Your Honor, I think what the city would request is that 45 days electronic home monitoring be converted back to jail. And that she serve that out, then she can certainly obtain that evaluation. I'm not sure if it was state certified chemical dependency evaluation that she received in Marysville or some other kind of evaluation. They don't usually do those in custody, so that's why I kind of question that. But I just don't have a lot of faith that she is going to complete the EHM if the court releases her to do that.
Madam Prosecutor, if I may, I do understand that you don't have that, so I understand what you're saying, and I apologize. I will be in compliance, and I'll make this happen this time, okay?
If the court does not allow her another chance for home monitoring, we have no objection to letting her serve the sentence in custody. Or not sentence, but the revocation.
45 days.
All right, so I think it's official. No one is buying her story. You think the judge did? Now, I like how the defense attorney said, we have no objection to her serving the rest of her time in jail. If she's not okayed on the house arrest program, yeah. What? How is that coming out of the defense attorney's mouth? Yeah, no, that's what's gonna happen if she's not approved of this. She's gonna serve the rest of her time in jail, but not objecting to it. He just had to get a word in. I do like this attorney. I'm poking fun at him just because I don't think that comment really did anything, but I do like this defense attorney. He's kind of everywhere.
So Ms. Malberg, I've heard from you. I'm going to impose a sanction. Is there anything else that you wish to say before I impose that sanction?
I'm sorry for keep coming here like this. I am. I apologize. The last thing that I'd like to say is that my warrants look massive, right? Like massive warrants. But each one of those is like 3 on one thing, if that makes sense. So one time of getting in trouble has more than one charge. And so each time I get 3 warrants set onto me. So it looks worse than it really is, if you will. And so
she likes big warrants and she cannot lie. The other jailers can't deny. I'm not going to keep going. I'm going to get struck.
It makes it really frustrating to be having so many different cities to do, even though the compliance is the exact same thing. I get overwhelmed with having to do it for each other, and then all of a sudden I don't have a phone anymore because somebody decided to steal my phone, and then I don't get, everything gets discombobulated and I'm lost. I'm hoping that doesn't happen this time. I'm gonna make damn sure it doesn't happen, because within 48 hours, I'm gonna be in compliance with everybody. So that, yeah.
Well, this is my concern.
Yeah.
I gave you a chance.
I know.
And what I understood you to be agreeing to do, what you said you were going to do, was to be staying at your mom's.
Yeah.
You acknowledge that you have a substance abuse issue and that has caused a lot of problems for you. I allowed that time to be served in EHM at your mom's house. Also fully expecting that you would get the substance abuse evaluation and follow-up treatment. So I understand things it was difficult getting out right around the holiday, but what I don't understand is why we have months and months and months when you chose not to re-engage and not to reach out to the court, and to not be at your mom's, because different notices were sent and you knew what you needed to do. You knew you needed to answer to this court, Bothell, Marysville. And, I'm sure it is overwhelming having all these courts coming at you.
She not only wants all of the last chances, she's involved with all of the courts. All the courts, all the last chances. She's She's got some big warrants out there, and she likes big warrants. She can't lie.
I am going to convert the 45 days back to straight jail time. I still want you to get the treatment.
Okay.
Your treatment, all those obligations, everyone wants you to get treatment.
I know.
Everyone hopes the best for you.
I know.
So I'm going to convert the 45 days back to actual jail time. You'll get credit from your day of booking on our warrant. So we'll figure out what day that was. Which one? So from May 13th. Let's see, you have 7 days on the 45, you'll do 30. Yes, concurrent is, that's fine. Within 48 hours of getting out of custody, you need to get in touch with Mr. Mitchell. You need to get that evaluation. You need to start doing the treatment.
Okay.
If going and staying at your mom's house is a more stable option for you, you need to do that.
Okay.
So addiction is terrible and it destroys a lot of people. And I'm hoping that you can get on top of it.
I'm trying. It's a slow climb, but I'm trying. I really am.
Just every day make a different choice and, you know, your partner, if they're struggling as well, sometimes it's better to separate and do what you need to do for you.
Okay.
So I know you don't want to be here. I know that Judge Rosano wants the best for you and it's just, we can't do it for you.
I know. I know. Thank you, guys.
We're gonna set a review date out and it'll be, you'll be about 30, let's set June 26th. That should be after you're done with your time. It'll be a 9 a.m. review hearing here.
Okay. Can it be a Zoom hearing? Because it
A
is,
what?
can it be a Zoom hearing? Because sometimes I don't have a vehicle.
If that's the only way you can get here, I
Okay,
would much rather you Zoom in and
I'll do my best to get here.
can't go silent.
Okay,
I
yeah,
will say that.
okay.
All right, I think that's it of this one. Now that I've let this clip play, there's only 15 minutes left of this video, so I'll just let it play out. There will be more pauses. I mean, I was going to just cut the video off now, but I forgot how long this one was.
One or two,
Yeah, sure.
they're new, so.
I fell asleep for a second there. Yeah. I've come close a couple times to falling asleep while I was live. I have. There are a few nights where I'm exhausted. All right, yeah, this should have been cut out. I'm sorry. I think all she's doing is signing her paperwork. I'm gonna skip ahead.
Thank you.
And next we have Genevieve Vintage. That's
All right, that one's done. Again, no idea what's next, but I think there's probably only one clip left.
Yes.
Oh, this is a good one to end it on. It's a little bit more upbeat. Judge Perkins. We all love Judge Perkins. And yeah, this guy. All right, let's go. You guys are all awesome. Thank you. I know this is a longer stream than usual, but you know, sometimes we need longer streams.
Your Honor, I have Mr. Gibson.
Let's go back on the record with Mr. Gibson. What's the offer gonna be with Mr. Gibson?
The offer was actually amended to the 2-point violation of, I believe it was the failing to. Sorry, Your Honor, 1 second. Let me look his name up again.
He's got a failure to use turn signal.
And that is the 2-point offense. And they were, the offer was to allow him to plead to admit responsibility to the 2-point offense versus the 3-point offense. In theory, 2 points versus 8 points. My client wishes to admit responsibility.
What do you mean by 8 points? Oh, improper
Because-
passing? I don't know
Yes.
if these 8 points. I always understood that the points would merge on a offense that he would just get the highest number of points. So if he committed, they're saying he committed these three moving violations in one offense.
That's
he would
correct.
get-
You are correct, Your Honor. That is correct. This is a city prosecutor. So that is correct.
It's really a 3-point offense to a 2-point offense, so it's 1 point reduction. Does your client want to take the deal?
Mr. Gibson, now that
I would have to go find a lot of content to do that. There would be a lot of me just not talking, or I'm sorry, there'd be a lot of me just feeling dead time. It would be really hard to get 24 hours of court content. I mean, I could play my old videos. We could do stuff like that. I can go, play my favorite of my old videos. I mean, that's possible. Could I stay awake for 24 hours? If I prepped for it, I could. I mean, when I do the trips to Detroit and back for the court crawls, by the end of the day, I'm generally close to about 20, 21 hours of being awake. I mean, I'm tired, but I still go live on those nights, so it's possible. It's possible.
you have that information, do you still want to admit responsibility?
I don't quite understand what y'all are saying.
So the allegations were that you improperly passed somebody, disregarded a red signal, and didn't use your turn signal, all on the same stop. And this is what the officer indicated that he witnessed. So basically what we were talking about was improper passing has 3 points. Disregarding a red signal has 3 points. Failure to use turn signal has 2 points. And we were saying that aside, if that's a total of 8 points, but when you get 3 tickets in one instance like this, the points would merge. And only the highest point total, if you were to plead to all of them, or got found responsible for all of them, only the highest point total would abstract. So you would only get 3 points out of all of these offenses, total of 3 points out of all of these offenses. But here, the city has agreed to give you just the 2-point offense of failure to use turn signal and dismissing the other cases. And you only have to have 2 points and 100. And I think.
Johnny, I can actually explain it to you in about 2 seconds. Well, more like 10. So I did a poll one night for the bonus clip I was going to play because I had 2 clips available. I don't remember what they were. So I just said, let's just say one was a sob sit, one was a Karen. So I put the poll up and I said, what do you want the bonus clip to be? Do you want it to be a sob sit or do you want it to be a Karen? And then as the funny third option, I just put I like turtles. And I like turtles won the poll. So now everyone's been asking for a turtle video because I promised a turtle video and I gave them a sob sit instead.
$5 fine, but it's still 2 points on your license. You either have the right to accept that, or you have the right to contest the officer saying that you did what you did. You have a right to contest it and say that you didn't do it if you want to, or you're only or whatever you want to do. You understand now?
Yeah, I understand.
What do you want to do?
I accept the offer.
All right. Stipulate to the face of the ticket as an accurate factual basis for the responsible plea. Counselor?
So stipulated, Your Honor.
Improbable cause for the dismissal of the driver's license.
So stipulated, Your Honor.
Find your client guilty as charged with the failure to use turn signal, $105, dismissing the other matters. When can you pay, Mr. Gibson?
Today.
So enlighten me, how did you pass somebody in property?
All right, we got all the legal stuff out of the way. This is when this case gets interesting. You know, his story and Judge Perkins' reaction to his story is just And we get a curse word out of Judge Perkins. Another thing, this courtroom is tiny. That's about as big as it is right there. There might be one more row of church pews behind, all the way to the left, and that's it. This is almost exactly the size of the courtroom. I was surprised at how small it was.
Properly disregard a red signal and failure to use your signal. What did you do?
I was in the emergency, and I just passed up the people and went through the light.
So I don't believe the emergency part. I just don't believe it. But even if it's true, you're an emergency. So your emergency is putting everybody else's life at risk that's on the road in that intersection. How does
Actually, I was waiting behind it was 8 cars, and they were talking to each other. So I just went around them.
So you just lied to me.
How did I lie?
You weren't in the emergency. You were mad because the cars were in front of you.
No, I was in.
Or the emergency report was true.
Excuse me, Your Honor. We were all at the light, but I was like the 8th car. I was in the emergency, so I went around them and went through the light. I saw the officer, but I was in the emergency.
So you were in emergency. So making your emergency is going to put everybody else's life in that intersection at risk because of your emergency. So I'll wait.
All right. I hear everyone saying, he's making up this emergency thing. At the very end of the video, he doesn't say what happened, but he kind of does. So I'm just going to say right now, don't say he didn't make up the emergency, because I believe him. When you hear the end and Judge even says sorry, I'm sorry. So let's keep the fake story on the, let's not make fun of him for the story. He did something illegal and he got caught for it. But it's the Judge Perkins speech that he's about to drop right now, which is why this is in the video.
They say your shit is more important than everybody else's.
Nope.
That's what you said at that day and time.
No,
Basically, by doing that, that's what you're saying.
But that's not what happened.
Well, what happened is you went around the people, you ran through the light, and you're admitting to that. So what I'm saying is your important emergency overrides everything else out there right then at that time, because you did it.
Yeah. Right.
So that kid crossing the street or potentially riding his bike or this car coming in the other direction, you put your emergency over everybody.
Right. A terrible mistake.
You know what I typically see though, and the reason why I'm not going to question whether it's the emergency or not, but I see it every single solitary day. They go right by you and just go through the light because they don't want to wait. It has nothing to do, I'm sure, with everybody's probably going to say it's the emergency. Nobody's just going to come in here and say, oh, I just did it because I didn't feel like waiting. I don't think anybody would ever say that.
Well, I can prove to you it was an emergency.
Well, I'm accepting that it was an emergency. I'm just accepting your representation that it was, but I'm trying to point out to you.
I understand.
How dangerous that is.
True, that's true. I was willing to give my life up for my wife's life. That's true.
Well, you're willing to give your life up for your wife's life? Your wife's life's up? Because was she in the car with you?
No, I was going to attend to her.
To that emergency, but you're willing to run over everybody else on the road.
True that. I wasn't thinking right. I understand that. All
right, that's all. It's over with now. $105. Pay it at any DivDat kiosk, Mr. Gibson, in the city of Detroit, or I'm told you can upload the DivDat app to your phone, or come on down to the courthouse and pay it. You said you'd pay it today. I'll mark it for the day. How is your wife doing?
She's kind of doing all right. She just got out the hospital.
All right, we're gonna pray that she continues her recovery and that she is gets better. All right.
All right.
All right. If there's nothing further, have a very good day. Best of luck to you.
All right.
All right. This is the end of the video. That's it. Hour and 45 minutes. This is, I think the longest I've ever gone is 2 hours. So we're getting up there. But I believe him that he was in an emergency. Doesn't make what he did okay. But you don't get the court hearing a week later. So his wife just got out of the hospital and she's only kind of doing all right. I believe him. I believe something was going on with his wife and he made a rash decision to do something stupid. And you know what? If Heather's life was in danger and, she was just a couple miles from me, I would probably be making bad decisions too. Just saying. I don't know if I would have tried to go through an intersection around 8 cars. That I don't know if my mind would have gone there, but just saying, when someone you love is in danger, you do dumb things. All right, that's all I got. But like I said, I believe him. Thank you everyone for hanging out. Thank you all for let's see, we have super chats, gifted memberships. You guys are all awesome. I appreciate each and every one of you. All right, let's go hang out on Discord. Let's go. Yeah, you're right, Carla. Call 911. Yeah, I would have. That would have been my first thing to do. And the ambulance might have been on the way to his house. Who knows? I don't know if it was his house where the issue is. They didn't go into it, so I'm just, and every one of you are too. You're just like kind of speculating what could have possibly been the emergency that caused him to do that. I don't know. I've got my own theories though, but it doesn't matter. All right, you guys all have a great night. Let's go hang out on Discord. And yeah, until next time. Bye.
You too, man.
All right, and be safe out there, Detective Buffington. Have a good day.
You too. Thank you.
All right, let's go ahead.